Chapter 1. Constitutional Framework. The Constitution of India is the supreme law of India. It lays down the framework defining fundamental political principles and establishes the structure, procedures, powers and duties of government institutions. The Indian Constitution is the world's longest written constitution. In its current form, it has a preamble, 25 parts with 448 articles, 12 schedules and 101 amendments. Historical background. The British government started regulating the affairs of India through a series of acts. But their constitutional reforms were not genuinely guided towards ensuring responsible governance in India. Their basic purpose was to control the Indian administration through the office of Governor-General, Viceroy. In this process, the British government never thought to dilute the authoritative position of Governor-General. The provisions inserted through these acts aimed at weakening our national struggle. But at the same time, these acts contained amalgamation of various provisions that led to the foundation of our present Indian Constitution. Some of the major acts and their details are given as under. Regulating Act, 1773. This act was the first step in the direction of the consolidation of British rule and centralization of administration in India. The Governor of Bengal was made the Governor-General of the Company in India, and the governors of Madras and Bombay were subordinate to him. The first Governor-General was Lord Warren Hastings. Black Circle. The Supreme Court was established at Fort William, Calcutta, as the apex court in 1774. 1775. General Studies, Mains, Paper 2. Pitt's India Act, 1784. It was introduced to remove the drawbacks of the Regulating Act, 1773. It was named after the then Prime Minister of Britain, William Pitt. It placed the Indian affairs under the direct control of the British government. It created a new body called Board of Control for managing the political affairs. Charter Act, 1833. It is also known as the St. Helena Act, 1833. The beginning of constitution making done the British rule in India is found in this act. It made Governor-General of Bengal as the Governor-General of India, and all civil and military powers were vested in him. First Governor-General of India was Lord William Bentinck. The government of Bombay and Madras were deprived of the legislative powers. British colonization of India was legalized by this act. This ended the actions of the East India Company as a commercial body, and it became a purely administrative body. It attempted to introduce the open competition for selection of the civil servants. However, this provision was negated. Charter Act, 1853. The legislative and executive functions of the Governor-General's Council were separated by this act. It introduced a system of open competition as the basis for the recruitment of civil servants of the company. Accordingly, the Macaulay Committee, on the Indian Civil Service, was appointed in 1854. It introduced for the first time local representation in Indian Central Legislative Council. Government of India Act, 1858. The act transferred the government, territories and revenue of India from East India Company to the British Crown. The powers of British Crown were to be exercised by the Secretary of State for India, That's why the Secretary of State was a member of the British Cabinet and was assisted by the Council of India, having 15 of its members. The Secretary of State was vested with complete authority and control over the Indian administration through the Governor-General as his agent, and he was responsible solely to the British Parliament. The Governor-General was made Viceroy of India. Lord Canning was the first Viceroy of India. Indian Councils Act, 1861. This act for the first time introduced representative institution in India. Black Circle. It provided that the Governor-General's Executive Council should have some Indians as the non-official members while transacing the legislative business. In 1862, Lord Canning, the then Viceroy, nominated 3 Indians to his Legislative Council: the Raja of Benares, the Maharaja of Patiala, and Sir Dinker Rao. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. This policy of legislative devolution resulted in the grant of almost complete internal autonomy to the provinces in 1937. It also provided for the establishment of new legislative councils for Bengal, Northwestern Frontier Province, NWIP, of Punjab, which were established in 1862, 1866 and 1897 respectively. It empowers the Viceroy to make rules and orders for the more convenient transaction of business in the council. It also gave a recognition to the portfolio system introduced by Lord Canning 1859. Indian Council Act, 1892. The number of additional members in the Governor-General's Council was increased by the introduction of this act. Additional members in Provincial Legislative Assembly were also increased. It increased the functions of legislative councils and entitled them the power of discussing the budget and addressing questions to the executive. Constitutional Framework. 5. Indian Councils Act, 1909. This act was popularly known as Morley-Minto. Reforms. Lord Morley was the then Secretary of State. For India, Lord Minto was the then Viceroy of India. It changed the name from Central Legislative Council to the Imperial Legislative Council. The maximum number of nominated and elected members of the Legislative Council at the center was increased from 16 to 60, excluding ex officio members. It provided for the first time the association of Indians with the executive councils of the Viceroy and governors. Sachendra Prasad Sinha became the first Indian to join the Viceroy's Executive Council. He was appointed as a law member. It introduced the system of communal representation for Muslims. Lord Minto came to be known as the father of communal electorate. Government of India Act, 1919. The Government of India Act, 1919 was based to a great extent on the Montagu-Chelmsford Report. It has a separate preamble which declared that the objective of the British government is gradual introduction of responsible government in India. By the introduction of this act, bicameral legislature was established in the centre. The upper house was known as the Council of State and the lower house was named as Central Legislative Assembly. Black Circle. The membership of the upper house was fixed at 60 members while the lower house consisted of 146 members. The upper house was elected for 5 years and the lower house for 3 years. Black Circle separate electorate was retained for minorities. The system of diarchy was introduced in the provinces. The provincial subjects were divided into reserved and transferred ones. The subjects were divided between the center and provinces. The central subjects were defense, foreign affairs, currency, railway and telecommunication. The provincial subjects included education, health, irrigation and local government. Black Circle. The Governor-General's Executive Council was responsible to the Secretary of State for India, who was sitting in London. The Governor-General retained the right to certify any legislation which he considered essential. The Act provided for the establishment of a Public Service Commission, PSC, in India for the first time. Simon Commission was constituted for reporting the condition of India under British. The Commission recommended the abolition of diarchy system and extension of responsible government. Government of India Act, 1935. It provided for the establishment of an All India Federation consisting of provinces and princely states as units. But the federation never came into being as the princely states didn't join it. The Act divided the powers between the center and units by 3 lists: federal list, for center, with 59 items, provincial list, for provinces, with 54 items, and the concurrent list, for both, with 36 items. Residuary powers were given to the Viceroy. It introduced provincial autonomy instead of diarchy in the provinces. It introduced responsible governments in provinces. The governor was required to act with the advice of ministers responsible to the provincial legislature. The provinces were now autonomous units of administration in their own fixed spheres. It provided for the diarchy at the center. Thus, the federal subjects were divided into reserved subjects and transferred subjects. But this provision did not come into operation at all. It introduced bicameralism in 6 out of 11 provinces: Bengal, Bombay, Madras, Bihar, Assam in the United Provinces. There was a legislative council, upper house, and a legislative assembly, lower house. However, many restrictions were placed on them. It was established in 1942 to provide scientific and industrial research and development that maximizes the economic, environmental, and social benefits of India. CSIR's contribution in various domains are enlisted below. Biological sciences. An indigenous drug formulation against tuberculosis called Rhizorian has been developed in PPP, public-private partnership mode, which has drastically cut short the duration of TB treatment. Recently, India's first biofuel-powered flight was initiated with the help of CSIR technology for aviation-grade biofuel. The use of biojet fuel, apart from reducing greenhouse gas emission and sulfur 6. General Studies, Mains, Paper 2. It also provided separate electorates for depressed classes, scheduled castes, women and labor workers. It abolished the Council of India, established by the Government of India Act, 1858. The Secretary of State for India was provided with a team of advisors. It extended franchise and about 10% of the total population got the voting right. It provided for the establishment of a Reserve Bank of India, RBI, to control the currency and credit of the country. It provided for the establishment of a Federal Public Service Commission, Provincial Public Service Commission and Joint Public Service Commission for 2 or more provinces. It provided for the establishment of a federal court. The Cabinet Mission Plan. Black Circle. The Act provided that all the members of the interim Cabinet would be Indians and there would be minimum interference by the Viceroy. It also provided for formation of the Constituent Assembly on democratic principle of population. The Union government and its legislature were to have limited powers, dealing with finance, foreign affairs and communications. The Union would have powers necessary to raise the finances to manage the subjects. Thus, the Cabinet Mission Plan proposed a weak center. A constituent assembly was formed by the representatives of the provincial assemblies in the princely states. Each province was allotted a total number of seats in proportion to its population. The Constituent Assembly had to comprise 293 members from the British provinces and 93 members from the princely states. Indian Independence Act, 1947. This act provided for the creation of two independent dominions of India and Pakistan from August 15, 1947. It defined the territories of the two new dominions and made possible the adjustment of existing boundaries, and the accession of other boundaries was to be done by the Boundary Commission. The Dominion of Pakistan was to have two wings, East Pakistan and West Pakistan. East Pakistan comprised East Bengal and Sylhet district taken out from Assam. West Pakistan included the Northwest Frontier Province, West Punjab, Sindh and Baluchistan. The two dominions was to have a governor-general appointed by the king for the purpose of governing the dominion. The act also provided that the same person could be appointed governor-general of both the dominions. The legislature of each of the dominions is free to make laws for that dominion, including the laws having extraterritorial operation. Black Circle No Act of British Parliament passed after August 15, 1947 to extend either of the dominions. The lordship of British government over the Indian states lapsed, and with it, all treaties and agreements between Britishers and the rules of Indian states also came to an end. The Indian states became independent in their political relations with the governments of the new dominions. The assent of the Parliament was given for the omission of the royal titles like Emperor of India. Dominion, provinces and other parts were governed in accordance with the Government of India Act, 1935 for the interim period. The provisions requiring the Governor-General or any other governor to act in his discretion or exercise of his individual judgment would cease to have effect from August 15, 1947. The Governor-General was, however, invested with absolute powers until March 1948 to issue orders for the effective implementation of Indian Independence Act, 1947, the division of the assets between the two dominions, to adopt or modify the Government of India Act, 1935, and to remove any difficulties that might arise during the transitional period. The Act of 1947 provided for the abolition of the office of the Secretary of State for India and his advisors. The two dominions were given freedom to join or not to join the Commonwealth. Initiatives have been made to promote research on development of solar energy-based technologies for both grid-based and decentralized generation and applications. 3. Constitutional Framework. 7. The members of the civil service and the judges of the federal court and high courts appointed before August 15, 1947 would continue to serve in either of two dominions and would be entitled to receive all facilities in respect of their remuneration, leave, term, pension, etc. as they enjoyed before independence. Salient features of the Indian Constitution. Constitution of India is unique in itself. Many features of our Constitution are borrowed from various sources around the world. That's why sometimes a few people criticize Indian constitution as being a borrowed constitution. Though, we have derived many features, yet we have modified those provisions to suit our need. Hence altogether new provisions have been created and assimilated in our Indian constitution. Some of the salient features of the Constitution of India are given as under. Written, lengthy and detailed. Like the Constitution of the United States of America, Canada and France, India too has a written constitution, though it differs from those documents in many respects. The Constitution of India is very elaborately written one, which makes it the most voluminous constitution in the world. It has been the endeavor of the framers of the Constitution to provide for the solution of all the problems of administration and governance of the country. Even those matters which are subject of conventions in other countries have been put down in black and white. The Constitution of India in original form consisted of 395 articles and 8 schedules. As a result of some amendments made since then, some new articles have been added and some old ones have been repealed. The number of schedules has also risen. However, the bulk of the Constitution continues to remain same. Accumulation of borrowed wisdom of the world. The Constitution makers borrowed suitable and tried principles of other constitutions of the world. The parliamentary type of government has been adopted from England. The Supreme Court in chapter on fundamental rights show the clear influence of Constitution of United States. From Irish state came the inspiration of the directive principles of state policy. The Federation of India is set on the pattern of Canada, where residuary powers are given to the center. Indian Constitution is thus a blend of many constitutions. Amalgamation of rigid and flexible. The Indian Constitution is partly rigid and partly flexible. The procedure laid down by the Constitution for its amendment is neither very easy as in the case of England nor very difficult as in the case of United States. A constitutional amendment can be initiated in either house of the Parliament. It can be passed by an absolute majority of the total membership of each house voting separately and 2/3 road majority of the members present in voting. But certain parts of the Constitution can only be amended with subsequent ratification by legislatures of at least half of the states. The state legislatures have not been given any powers to amend the Constitution because they do not have separate constitution. In Canada and Australia, both the provinces and the states can amend their own constitution within the federal framework. The socialist aspect of Indian Constitution. The word socialism has not been used in the original Constitution, but the essence of the philosophy of socialism is inherent in it by establishment of a society based on equality, economic justice and non-exploitation. The provisions of the Constitution dealing with the preamble of the Constitution, the fundamental rights, the directive principles, the special provisions for the scheduled castes and scheduled tribes, the schedules D and B of the Constitution, aim directly at achieving the goals of the social aspect. Eight. General Studies, Mains, Paper 2. Essentially federal with unitary features. The Constitution declares that India or Bharat shall be a union of states. It provides for a double set of governments. In this set of dual polity, powers are clearly defined and demarcated. The provision that take part in distribution of powers are as follows. Legislators of the center as well as state participate in the election of president under Articles 54 and 55. Demarcation of executive powers between the center and state under Articles 73 and 162. Legislative powers between the center and state are well distributed under the range of Schedule 7 providing Union List 100, State List 61, and concurrent last 52. The upper house, Rajya Sabha, is represented by the states. Compulsory ratification by at least half of the states for amending above provisions. In spite of having substantial federal features, Indian Constitution is strikingly characterized by a host of centralizing features, some of which are as follows. No separate constitution for states. No dual citizenship. Authoritative power of center to change the name, boundary and territory of any state. In addition to residuary power to center. Central law prevails over the state law in conflicting matters of Schedule 7. National emergency, president rule, financial emergency are another examples depicting centralized features. Appointment of high court judges without much say of the states. Appointment and role of the governor is inclined heavily towards center. Common election commissions, CAG etc. are another such features. Indian federalism can be termed as quasi-federal in light of above-mentioned features. Parliamentary system of government. The Constitution establishes parliamentary type of government, both at the center and the state. It follows the British cabinet system with the Prime Minister as the head of the executive of the Union. The real powers are vested and exercised by the Council of Ministers, which is responsible to the legislatures. The President and the Governor are merely constitutional heads. The parliamentary system of government, as in the Great Britain, has been adopted primarily because of the success of this system in England and also because of the political experience of the Indian people gathered from the working of partial responsible governments under the Government of India Acts, 1919 and 1935. Single citizenship. Although India has a federal government, yet double citizenship, as provided for in the U.S. Constitution, has not been provided for. All the Indians, irrespective of their domicile, enjoy a single citizenship of India. Since Americans are considered to be the citizens of the respective state where they are domiciled, and then they are also the citizens of the USA as a whole. In both these capacities, they enjoy different rights and owe different obligations. The principle of single citizenship was provided for in the Indian Constitution in order to foster strong bond of social and political unity among the people of India who were divided on account of race, ethnicity, languages and multiplicity of religious and cultural background. Directive principles of state policy. The directive principles of state policy are another distinctive feature of the Indian Constitution. This feature has been taken from the Constitution of the Ireland. These are the ideals which the state shall strive to achieve as far as possible. These principles are non-justiciable. No legal action can be taken against the state in courts of law if it fails to follow or realize any of these principles. They do not confer any constitutional rights upon citizens, and these cannot be enforced through courts of law as in case of fundamental rights. However, these principles have been made fundamental in the governance of the country. It becomes the moral duty of every government authority to follow them and realize the purpose behind them. Constitutional framework. 9. Fundamental rights. Like the Constitution of the United States of America, The Constitution of India also includes a separate chapter guaranteeing fundamental rights to all the Chusans. These rights are justiciable and inviolable. They are binding on the legislature as well as on the executive. If any of the rights is violated, a citizen has the right to seek the protection of the judiciary. Any act of the legislature or order of the executive can be declared null and void if it violates any of the fundamental rights guaranteed to the citizens by the Constitution. Independence of judiciary. Our Constitution established an independent judiciary, absolutely free from the influence of the executive and legislature. The Supreme Court of India has declared executive orders and ordinances null and void whenever they were found to be inconsistent with the provisions of the Constitution. Annulment of ordinances with respect to privy purses and bank nationalization are some of the cases where the Supreme Court exhibited its complete independence and neutrality. Balance between judicial supremacy and parliamentary sovereignty. The Constitution of India is a refined blending of judicial supremacy and parliamentary sovereignty. It avoids the extra super authority of the Supreme Court of America, which can invalidate any act of the American Congress on the simple plea of its being contrary to the spirit of the Constitution. This power of judicial review has made the Supreme Court of America a super legislature. The British Constitution, on the other hand, embodies the principle of parliamentary sovereignty. The British Parliament can pass, amend, repeal any type of legislation, good or bad, natural or unnatural, in the Constitution. Courts in England cannot declare null and void any act of Parliament on any ground whatsoever. The Indian Constitution strikes a golden mean by avoiding judicial supremacy of the American type and parliamentary sovereignty of the British type. The Supreme Court have power of judicial review and can stand in judgment over the sovereign will of Parliament in ensuring justice for the people. Parliament is absolutely supreme in the sphere of legislation within the bounds of basic structure of the Constitution. This is how a compromise between the British and American systems has been beautifully executed in the Indian Constitution. Basic Features Doctrine. In the Keshavanand Bharati case, 1973, the Supreme Court propounded the doctrine of implied and inherent limitations along with the doctrine of basic features, which were until now unknown in India. In this case, the majority of judges held that the amending power was a limited one, even though they knew that the legislature was bent upon giving unlimited amending power to itself. The Supreme Court put forward the view that undoubtedly the Constitution does not have any provision for drafting a new constitution, but that does not mean that the legislature can't reshape or restructure the Constitution. It is therefore logical to assume that the implied limitation restricts the legislature in changing the Constitution unidentifiably. An argument stating that Parliament's will is people's will and therefore, Parliament still has an unlimited amending power, is preposterous because the electorate docs nor take into account the constitutional amendments while voting in the parliamentary elections. So what has to be understood clearly is that Article 368 allows the legislature to make amendments only to the extent that the Constitution does not lose its unique identity. The Parliament, by passing the 24th Amendment Act, altered Article 368 to enlarge the ambit of its amending power under that very article. This is a clear violation of the principle of implied limitation. A creature of the Constitution cannot regard itself superior to the. To sum up, the Supreme Court held that the Constitution is not made to suffer a loss of identity through the amending process. The identity of the Constitution is the sum of its essential features. Article 368 cannot be read as expressing the death wish of the Constitution or a provision for its legal suicide. Earth Sciences. The government of India reorganized the Ministry of Ocean Development, and the new Ministry of Earth Sciences, MPS, came into being on the 12th 10. of July 2000. General Studies, Mains, Paper 2. It was held by the Supreme Court that Parliament's power of amendment was subject to implied limitation, namely, Parliament could not amend the Constitution to bring about change in the basic features of the Constitution. Elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution including the fundamental rights, but without affecting the basic structure of the Constitution. From the various judgments, the following have emerged as basic features of the Constitution or elements of basic structure of the Constitution. Supremacy of the Constitution. Sovereign, democratic and republican nature of the Indian polity. Secular character of the Constitution. Separation of powers between the executive and the judiciary. Legislature. Federal character of the Constitution, unity and integrity of the nation. Welfare state, socio-economic justice. Judicial review. Freedom and dignity of the individual. Parliamentary system, rule of law. Harmony and balance between fundamental right and DPSPs. Principle of equality. Free and fair elections. Independence of judiciary. Limited power of Parliament to amend the Constitution. Effective access to justice. Principle of reasonableness. Powers of the Supreme Court under Article 32, 136, 141 and 142. Separation of powers. The doctrine of separation of powers considered the idea that the governmental functions must be based on a tripartite division of legislature, executive and judiciary. The three organs should be separate, distinct and sovereigns in its own sphere so that one does not trespass the territory of the other. The framers of Indian Constitution did not recognize the doctrine of separation of powers in a rigid sense. Unlike the American Constitution, this doctrine has not been strictly applied in the Indian Constitution. It cannot be explicitly seen, but can be witnessed through the differentiation made in the discharge of functions by the different branches of the government in the Constitution. A complete and absolute separation of powers is practically and theoretically not possible. Though, it is always possible to give a broad meaning to this doctrine. The basic concept of the separation of powers would mean that the same persons should not form part of more than one of the three organs of government. That one organ of government should not control or interfere with the work of another. Black circle. That one organ of government should not exercise the functions of another. Democracy and separation of power. The doctrine of separation of powers is an integral part of the evolution of democracy. Democracy dictates a system in which every citizen can, without fear of retribution, breath, express himself and pursue his or her interests. It enables him to live a life of his choice to the extent he does not encroach upon the rights of the other people. The legislature, the judiciary and the executive are the pillars of democracy. No democracy indeed contemplates conferment of absolute power in any single authority. Therefore, the system of checks and balances is one of the most salient features of our constitutional scheme. Practically, the three organs cannot be segregated into three watertight compartments due to their interdependence on each other to ensure efficacious governance. They have to work in accordance and in consonance to achieve a meaningful sustenance and purposeful progress of citizens. Though the minimum encroachment is always desirable, The conscience of our Constitution speaks through its preamble, and the dynamics of its goal is spelled out in its various provision. The will of the people finds its best expression in the every word as inscribed in the preamble. We the people of India, and do hereby adopt, enact and give ourselves this Constitution. Thus, it is the people who are sovereign, and they exercise this sovereign power in choosing their representatives to the Parliament. Constitutional Framework. 11. Conclusion. Constitution is the supreme law of the land. No organ should go beyond the role assigned to it by the Constitution. It is the obligation of the judiciary, executive and legislature to adhere strictly. One of the most fundamental features of the Constitution is separation of powers. It is needless to criticize the constitutional plan of separation of powers when the existing provisions are not being religiously followed. There is a major gap between the constitutional plan and practice of separation of powers. It can only be bridged when all the three organs move a step ahead than all the other democracies of the world by working in sheer harmony. The founding fathers of the Constitution had also defined the position and the powers of the three organs of the state. They had realized that government, being an organic entity, would never be able to achieve complete separation of powers. Therefore, aiming for a complete separation of powers is misconception. The spirit of the Constitution is not exclusiveness, but a shared coordination. The executive has grown very powerful in the recent time, which has certainly led to wide misuse of powers. Apart from the check kept on them by the judiciary and legislature, media and NGOs have played a major role in exposing the misdeeds of government functionaries. Ultimately, the aim of the three organs is to protect the rights of the people. In a democracy, vigilant attitude of the people can help ensuring a proper functioning and prevent arbitrary exercise of the power. Therefore, none of the three organs can usurp the essential functions of the organs, which constitute the basic structure, not even by amending the Constitution, and if any such amendment is made, the court will strike it down as unconstitutional. These basic features forms the bedrock of Indian Constitution, which reflects the real spirit and ethos. Now further in this chapter we will discuss various parts of the Constitution. Preamble. Preamble refers to the introduction of the Constitution. Indian Constitution borrowed the concept of preamble from the American Constitution. The preamble of the Indian Constitution is given below. The preamble is the introduction of the Constitution. The preamble of Indian Constitution is given below. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual in the unity and integrity of the nation. In our Constituent Assembly this 26th day of November, 1949, do hereby adopt, enact and give to ourselves this Constitution. Important words mentioned in the preamble such as sovereign, socialist, secular, democratic republic, justice, liberty, equality, fraternity, etc. reflect the high ideals of the framers of the Constitution, as well as they also reflect the wishes and aspirations of people of India. Components of preamble. Broadly, the preamble reveals following four components of the Indian Constitution. 1. It is the source of the authority of the Constitution of India. 2. It reveals the nature of the Indian state. 3. It reveals the objectives of the Constitution of India. 4. It also reveals the date of adoption of the Constitution of India. General Studies, Mains Paper I. Shared infrastructure for product development and validation, besides providing specific training to address the critical skill gaps in this sector. E. Promoting 12. General Studies, Mains Paper 2. Significance of Preamble. The preamble is very important for the Constitution of India. The preamble has been referred to as the key to the minds of the makers of the Constitution. The important and significant features of the preamble are given as under. The preamble contains the basic philosophy on which the Constitution is based. Black circle, it reflects vision, ideals and aspirations of the framers of the Constitution of India. Some of the important comments about preamble, which show the significance of preamble, are as follows. Horoscope of our sovereign democratic republic, K.M. Munshi. The preamble is the most important part of the Constitution. It is the soul of the Constitution. Professor Thakur Das Bargana, it is keynote to the Constitution, Ernest Baker. Whether preamble is a part of the Constitution. The relationship of preamble with the Constitution and its amendability has always been a matter of debate. The Supreme Court of India has given different judgments in different matters. In 1960, in the Barubari Union case, the Supreme Court admitted that the preamble is key to the minds of the framers of the Constitution, but it is not part of the Constitution. In Keshavanand Bharati case 1973, the Supreme Court observed that the preamble is an integral part of the Constitution. Now, it is widely agreed that the preamble is an integral part of the Constitution. Black circle doesn't give any authority or check upon legislature. Black circle, its provisions are not enforceable in the court of law. Whether preamble is amendable. In the Keshavanand Bharati case, 1973, the Supreme Court observed that as preamble is part of Constitution, therefore, it is amendable like any other part. But no amendment can be made to the basic features as mentioned in the preamble. In 1976, Through 42nd Constitutional Amendment Act, the preamble was amended where words socialist, secular and integrity were added to it. Citizenship. The Constitution of India provides a single citizenship for all the citizens of India. It is dealt in Articles 5 to 11 under Part 2 of the Constitution. These articles empower the Parliament to enact a law related to the citizenship. It led to enactment of Citizenship Act, 1955, which was amended many times subsequently. Acquisition of citizenship. There are 5 ways of acquiring citizenship of India according to the Citizenship Act, 1955. These are given as under. By birth. A person born in India between the 26th of January 1950 and the 1st of July 1987 is citizen of India by birth irrespective of nationality of his parents. However, a person born in India on or after the 1st of July 1987 is considered as citizen of India only if either of his parents is citizen of India at the time of his birth. Those born in India after the 3rd of December 2004 are considered as citizen of India if both of his parents are citizen of India. By descent. A person born outside India between the 26th of January 1950 and the 10th of December 1992 is considered as citizen of India if his father was a citizen of India at the time of his birth. For those who were born after the 10th of December 1992, they are considered citizen of India by descent if either of his parents were citizens of India at the time of his birth. However, the 3rd of December 2004 onwards, a person born outside India shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of the date of his birth. Constitutional Framework. 13. By registration. A person may get citizenship of India on an application if he falls under any of the following categories. A person of Indian origin who is ordinarily resident in India for 7 years before making an application. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application. Minor children of persons who are citizens of India. Black circle, a person of full age and capacity whose parents are registered as citizens of India. A person of full age and capacity who, or either of his parents, was earlier citizen of independent India and has been residing in India for 1 year immediately before making an application. A person of full age and capacity who has been registered as an overseas citizen of India for 5 years and who has been residing in India for 1 year before making an application. By naturalization. The citizenship of India can be acquired through the process of naturalization on the following grounds. Black circled that he is not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens. Black circled that he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. That he has either resided in India or been in the service of government in India throughout the period of 12 months immediately preceding the date of application. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in service of government in India for periods amounting to not less than 11 years. That he is of good character. That he has an adequate knowledge of a language specified in the 8th schedule of the Constitution. That after getting certificate of naturalization, he intends to reside in India. By incorporation of territory. If any foreign territory becomes a part of India, the government of India specifies persons who among the people of territory shall be the citizen of India. Loss of citizenship. According to the Citizenship Act, 1955, the citizenship can be lost in following 3 ways. 1. By renunciation if any citizen of India of full age and capacity makes a declaration renouncing his Indian citizenship. 2. By termination when any Indian citizen voluntarily acquires the citizenship of another county, his Indian citizenship terminates automatically. 3. By deprivation under this, the citizenship is lost compulsorily on the following grounds. Fraud. If the Indian citizenship was acquired through. If he has shown disloyalty to the Constitution of India. If he has unlawfully traded or communicated with an enemy during the war. If he has ordinarily resided out of India for 7 years continuously. Person of Indian origin, PIO, and overseas citizens of India, OCI. The person registered as PIO or governed under the Ministry of Home Affairs scheme. Following persons are eligible for PIO card. Anyone who held Indian passport anytime. He or either of his parents or grandparents or great-grandparents was born in and was permanently resident in India. He is spouse of a citizen of India or a person of Indian origin as mentioned above. Impactful policy research in social science, impressive scheme. The Ministry for Human Resource Development launched the web portal of the scheme, Impactful Policy Research in Social Sciences, Impress, in 2018. Under the scheme, 1,500 research projects will be awarded for 2 years to support the social science research in the higher educational institution and to enable research to guide policy-making. Impress scheme will be used to understand and solve problems facing the society. The scheme will be implemented at a total cost of 14. General Studies, Mains, Paper 2. On the other hand, the OCIs are governed as per fundamental rights. The Citizenship Act, 1955. Following persons are eligible for becoming OCI. A foreign national who was eligible to become a citizen of India on the 26th of January 1950. A person who was a citizen of India on or at anytime after the 26th of January 1950. He who belonged to a territory that became part of India after the 15th of August 1947. His, her children of such person. Minor children of such person. However, these schemes are not available to